This conference will now be recorded.
We are recording.
Good morning. Good afternoon, sorry. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our October 21st, 2020 public meeting. This meeting is being held via teleconference in accordance with legislation signed by Governor Hochul on September 2nd, 2021, due to the ongoing coronavirus emergency. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. We'll first turn to our vote on the minutes from the September 23rd, 2021 public meeting. Are there any corrections or comments to these minutes? Absent any comments or corrections, do I have a motion to accept these minutes? Mr. Delaney has indicated. Is there a second? Mr. Hilton. Thank you. Ms. Rivera, could you please poll the board members?
Mr. Bowers?
Yes.
Mr. Roche?
Mr. Roche is absent.
Mr. Hilton?
Yes.
Mr. Delaney?
Yes.
Ms. Roseland?
Yes.
Ms. Otto?
Yes.
Chairperson Hilton?
Yes.
6 in favor,
And 3 absent, correct?
3 absent.
Thank you, Ms. Rivera. The next thing on our agenda is the Executive Director's report by Mr. Schultz. Mr. Schultz?
Good afternoon, everyone. Thanks for joining us. As usual, I'll start by noting what Chairperson Hilton already said, but that we are still, due to the ongoing public health crisis, doing the in-person board meeting requirements are suspended through January 15, 2022. That remains true. So the meetings until then will be remain to be virtual, just so the public is aware. It's been asked, and I have been providing a brief update on the Soho NoHo rezoning at each meeting, and there was an update yesterday. The City Planning Commission voted to approve it. That will, move it along to City Council, and so that is the status of the Soho NoHo rezoning. The unofficial loft board revenue for September was $79,945. On to enforcement. I want to start enforcement by first repeating what I said last month at the meeting. As fall and winter approach, we're calling on our owners to make sure the IMDs have heat and are reminding them the heat requirements under our rules. And owners, fire up your heating systems. Make sure they're working before it's too late, before it's too cold. If it's not working, you need to get those contractors in to get it fixed before those contractors become too popular. So now is the time. To that end, we sent a message out to our listserv about the 2021-2022 heat season and the requirements under our rules and the enforcement mechanisms related to it. I believe she didn't want me to credit her, but I'm going to do it anyway. Deputy Director Lynn did a very excellent job putting that together and getting that out. I want to thank her for that. It's very important. So if you did not receive it on the listserv, the email list, sign up for our email list on our website. And while you're there, you can click on our news and check out that information. September inspections consisted of a total of 34 inspections. A lot of credit to our inspector for that. And that resulted in 6 violations. 1 for a broken elevator, 1 for no gas, and 4 for a lack of loft board signage in the lobby vestibule as required. 2 of the 4 for the signage have been corrected. 2, we're working to seek compliance or enforcement if necessary. I'm going backwards, I'm sorry. The no gas remains unresolved, and the broken elevator has been corrected. There's one more small stat I want to share with respect to our enforcement, and it's just, in September, 7 times we basically resolved an issue from a tenant or a customer without an inspection, whether it was through a phone call. In other words, if our inspector and our attorney can do quite well by trying to resolve issues by connecting the owner and the tenant, or perhaps through a referral to the appropriate party. And that's it's not really mentioned often, but I wanted to mention that is a part of our enforcement work as well. When we don't have jurisdiction, we'll try to get it in the hands of someone who does, or if it's something that we think doesn't require our inspector's precious time, we'll try to do it without that and get compliance and resolution whenever possible. I have, did I skip? Oh, I skipped right over the first thing I wanted to mention. We have a new staff member by the name of David Silverstein. He is an accountant. He has city experience. He's worked for the comptroller for many years. He is we call a reservist. We have him for 15 hours a week. I wish we had him more, but we're very, very happy to have him. Before I started, it was my understanding that this office had an accountant to assist and be available for some of the complex rent calculations that are in the rules. And so having David on board, we're very pleased, very excited. I can tell you he's already a pleasure to work with, very eager to get things done, and we couldn't be more happy to have him on board. So welcome, David, who is with us here today. Let's see, litigation. I'll read it. We have 1 new case and 1 decision, which I'll share the details on. The new case is 16 Cypress Avenue Realty, LLC versus the New York City Loft Board. Index number 158634/2021. And here the petitioner, owner of 476 Jefferson Street in Brooklyn, filed an Article 78 petition to challenge Loft Board Order 5053, which is from May of 2021. And in that order, the board granted protected occupancy status to the tenants of Unit 306, named Haley Desjardins and Samuel Richter. And that order, 5053, was a reconsideration of a prior order numbered 4995 from July 16th of 2020. Both orders found that Unit 306 was not deregulated through a sale of loft law rights by prior tenants. And in its reconsideration, the Loft Board found that the owner was not denied due process. And the Loft Board rejected the owner's arguments that a sale of rights does not require analysis of whether a tenant knowingly waived their rights. In the reconsideration, the board found that there was no error in the underlying order, and that order being that the prior tenant failed to effectuate a knowing waiver of lawful rights. In this Article 78, the owners now argue that those prior orders should be annulled because oath testimony and documents, they say, evidence that one of the prior tenants knew that he was a protected occupant when he agreed to the sale of rights. And the owners also argue that adequate consideration was exchanged for that sale. And so that's a new ongoing case. The other litigation update is a decision, a case called Texeria and Sullivan versus the New York City Loft Board. It's index number 511233-2020. And in this Article 78, filed by 6th floor occupants at 216 Plymouth Street in Brooklyn. They challenged Loft Board Order 4945 from February 20th of 2020. And that order granted loft law coverage to the 2nd, 3rd, and 4th floors, but not the 6th floor unit. Evidence showed that the 6th floor unit was used for a construction business during the window period. Occupants of the 6th floor filed the Article 78, claiming that the part of the order that denied coverage for the 6th floor was in error. The court denied this petition, stating that the petitioner failed to identify an applicable section of the CPLR to challenge the Loft Board's determination, and that they also failed to cite pertinent legal authority. The court stated that the Loft Board's determination was rational and not arbitrary or capricious, and that that court, that Article 78 court, may not weigh evidence or reject the credibility determinations made by oath and the Loft Board. I want to give a brief update on, excuse me, let's see. On the last month, we had some discussion of our failure to register orders, and I just wanted to confirm for our board members, there are no other orders to be issued. There was a few that we had discussed may come. Those have been reviewed and been found not valid for bringing them in order, and so I wanted to, I guess, put a cap on that piece. I don't have anything else. Thank you very much.
If you don't mind, since you brought up Soho, NoHo, also Chinatown, I've been, as some of you know, I've been active in artist housing since the early 1960s. When I went to look at that building at 482 Broadway, I said, gee, I might as well walk all around Soho and take a look. There's no doubt that Soho is a very glamorous place. And why is it glamorous? Because the artists moved in there. And then the galleries came in. And then Macy's and Bergdorf Goodman and so on and so forth came into play. So walking around Soho, you would have the impression that this was a high-end place where a lot of maybe rich people are there. That is true. On the other hand, I started looking at the buildings and seeing buzzers, 1, 2, 3, 4, 5, 6, with names on it, so on and so forth. How many artists are still in Soho? I have no idea. But the idea now that it is a high-end, expensive place, it may be for the for these nice stores that are there, but it's not necessarily for the artists. The first meeting I attended was about 4 or 5 years ago, and there were maybe 60 or 70 artists there, all somewhat older, outraged by the fact that the city was going to do whatever it decided to do. And there was no doubt, attending many of these meetings, a lot of the people that were arguing for the redistricting of the two areas, by the way, I live in NoHo, were good-hearted people wanting to make the city more diverse. I'm absolutely for that in every sense. But once again, walking around, I found maybe 2 empty lots. And then I would say to myself, what are they going to do? What buildings are going to tear down? There are a couple of new buildings in Soho, to be sure. There's a nice hotel there. There's one other very nice building. And so I don't know, really, even though this was passed and will now go to the city council, which will be passed, whether or not they'll be able to do whatever they said they're planning to do, because the building, as anybody knows, are filled with buildings. So I just want to put that into the record, even though it has nothing to do with the loft law, except for those that are protected there by the loft law that are in Soho and NoHo.
Thank you, Thank you, Mr. Borowitz. Is there any other comments or questions from Mr. Schultz? Yes, Mr. Delaney. You have to take yourself off.
Yes, yes. It's in the end of the minutes, and at the end of the last meeting, I had asked that at some point in the future we have a discussion on communication, last minute communication to the board on cases, and I'm just asking for an update on where we are with that.
Mr. Schultz, you're on mute.
Yeah, so I mean, as far as an update of putting it on the agenda, we did not put it on this agenda because we wanted to prioritize rulemaking. And I guess I'll just be more precise. What other type of update, if any? I mean, it's something that I've reviewed the rules and laws on it. I think that there's some areas in which the board can probably make some determinations on how it wants to handle that, and it's a conversation to be had.
Right. So I guess my question is, given that it's a conversation to be had, when's it going to be had?
When the chairperson puts it on the agenda, and that could be, you know, it's not today unless there's some sort of action that puts it on the agenda. We have a November 4th meeting that is currently slated for rulemaking. And then we have another November meeting that, if the board wishes it, you know, the chair wishes it, I should say, it could be on the agenda.
Okay, thanks.
Mr. Delaney, just offline, maybe you work with Mr. Schultz and try to solidify a date, a future date. Yeah?
Sure.
Thank you. Absent any other comments, any other comments, questions for Mr. Schultz?
Oh, I'm sorry, I do have one more question. You mentioned that the heat requirements went out via the listserv, I believe. Is that correct?
Yes, the listserv, which is our email distribution list.
Right. And my question is, how big is that list now?
Someone asked me that same question this morning, and I did not know the answer. I'm going to find out.
Okay.
If anybody knows, please
Hold on.
speak up.
Hold on.
Thank you.
I won't tell you who told me the exact amount, but you guys can figure it out. 176. So I'm so smart and up to speed. But thank you, Ms. Rivera. 176, Mr. Delaney.
He gets the smart staff right next to him for all the hard questions.
Obviously, we would love for that list to grow. We're working on maybe putting that, Mr. Delaney, also on our website. Information, up on our website. We're going to do
it is on the website. We're going to work on putting it in some better real estate.
Okay, great. Thank you. Speaking of that, I'm filling in for Mr. Our fire department representative here, Mr. Roche. He would normally at this time remind tenants and of safeties regarding the heating season, and also owners of their obligation to provide carbon monoxide detectors. It is a law, it is the law that each unit is outfitted with at least a carbon monoxide detector in each apartment, and also depend on how big the apartment is. So please, owners, must know that, but I want to make sure tenants are aware that they must have a working carbon monoxide detector in their units, and if not, please, for your own safety, reach out to your landlords, make sure that those are being provided and in proper working condition. This is all about lives and safety. So we want to see everybody go through this season in good condition. So that's just a fire department service announcement I know Mr. Roche would have chipped in with. Okay, thank you. Are there any other questions for Mr. Schultz? Thank you, Kevin. Good job on that. There are we're going now to appeals and reconsideration calendar. There were 2 cases on the appeals and reconsideration calendar. The first case is certain tenants of 400 2nd Street. The address is 394 to 400 2nd Street in Brooklyn, which the chair has decided to table at this time. The second case is OnStar Inc., 207 Star Street, Brooklyn, New York, and that docket number is AD0112. Ms. Lee will present this case. You're on mute.
You're on mute, Ms. Lee.
Thank you, Chairperson Hilton. This case involves an appeal application in which the owner of the building challenges an administrative determination dated September 28, 2020, that was made by the then acting executive director of the Loft Board. The administrative determination, among other things, rejected sales filings that the owner had submitted for units 2-2 and 3-3 on July 20th, 2020. In order to demonstrate an effective sale of Loft Law rights, one must provide sufficient proof of a tenant's intentional relinquishment of a known right. Here, the administrative determination rejected the sales filings, which comprised sales agreements and sales record forms for units 2-2 and 3-3, because the owner had failed to meet this burden of proof. On appeal, the owner contends that there is substantial evidence in the record to show an intentional relinquishment of known Loft Law rights. This proposed order disagrees. In support of its claim, the owner argues that the sales agreements are sufficient proof. This proposed order finds that they are not. The sales agreements make no references to the Loft Law or to the relevant portions thereof. While the Loft Board has upheld the validity of sales agreements that do not explicitly cite MDL Section 286.12, it has done so when the circumstances of those sales clearly demonstrate that valid sales occurred. Here, in the underlying matter, the owner failed to provide sufficient evidence in regard to the circumstances of the alleged sales. The owner also argues that the sales record forms are sufficient proof. This proposed order finds that they are not. The Loft Board's rules, specifically 29 RCNY Section 2-10B, require that owners submit, in addition to sales record forms, sales agreements or other documentation to substantiate the alleged sales under MDL Section 286.12. Additionally, the Loft Board has previously held that the acceptance of a sales record form by the Loft Board staff is merely a ministerial act and cannot be considered a determination that the alleged transaction was a sale of Loft Law rights. Furthermore, the Loft Board has previously held that absent additional evidence, a signed sales record form does not adequately prove a tenant's intent to relinquish his or her rights under the Loft Law. Moreover, a tenant's certification on a sales record form only pertains to the tenant's knowledge and belief that the sales record form and any additional documentation which accompanies the sales record form are accurate. There is no language in the sales record form that expressly waives Loft Law rights. Insofar as the owner contends that the sales record forms, together with the sales agreements, demonstrate an intentional relinquishment of known Loft Law rights, this proposed order finds that this argument is uncompelling. As previously discussed, a sales record form neither adequately proves a tenant's intent to relinquish his or her rights under the Loft Law, nor establishes the sale of rights under the Loft Law. Additional evidence must be offered in support of an alleged sale under MDL Section 286.12. Pursuant to 29 RCNY Section 2-10B, either a sales agreement or other documentation substantiating the alleged sale must be provided. Here, the owner provided sales agreements for units 2-2 and 3-3. However, the sales agreements make no references to the Loft Law. The Loft Board may consider additional evidence concerning the circumstances of the alleged sales in order to determine whether deregulating events have occurred. However, here, the record contains insufficient evidence as to the circumstances of the alleged sales. Therefore, even when considering the sales record forms and the sales agreements together, the administrative record does not sufficiently demonstrate an intentional relinquishment of known Loft Law rights. In sum, this proposed order holds that the facts found in the administrative determination are supported by substantial evidence in the record, and that the then acting executive director correctly applied the law. This proposed order denies the owner's appeal.
Thank you, Ms. Lee. Do I have a motion to accept this case? Mr. Borowitz, do I have a second? Mr. Delaney. Thank you. Are there any comments on these cases? On this case? Mr. Borowitz, did you? No. No comments?
I'll make a comment, just for the sake of the public who's following along. There were, I don't know, 10 or so questions and issues raised by this case and this proposed order that actually have nothing to do with the proposed order itself, but had to do with a commercial tenant being the protected occupant and a number of other issues and or questions. So for anyone following along who wants to thoroughly read through this, it's much more complicated than it appears on its surface. And it was an interesting, a number of interesting questions were raised.
Thank you, Ms. Rosalind. Are there any more comments? Mr. Hilton, I see you're off mute. Do you want to say?
Yeah, I would say that seconding what Ms. Rosalind stated, there were a number of questions that were raised, but I would say all matters were considered fairly thoroughly.
Thank you. Thank you, Mr. Hilton. Are there any other comments? Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Chairperson Hilton,
Yes.
6 in favor, 3 absent.
Thank you, Ms. Rivera. There are two cases on the summary calendar, and those two cases are tenants of 475 Kent Avenue. The address is 473 through 493 Kent Avenue in Brooklyn. Mr. Schultz, could you just make sure, is that 473 through 493 or 495? Just want to make sure.
Yeah, I mean,
Yeah, 1 second.
I'm sorry, ask the question again.
Address is that
Address 473 to 493 is the address of record for this building.
Thank you. I seem to remember something different. Okay, 473 through 493 Kent Avenue in Brooklyn, New York, and that docket number is TM0102. The other case on the summary calendar is 473 through 493 Kent Avenue, and the address is 473 through 493 Kent Avenue, Brooklyn, and that docket number is BP0057. Do we have a motion to accept these cases? Ms. Rosalind, and do I have a second? Ms. Otto, thank you. Ms. Rivera, could you please, excuse me, are there any comments? Absent any comments? Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roslin,
Yes.
Ms. Otto,
Yes.
Chairperson Hilton,
Yeah.
6 in favor, 3 absent.
Thank you, Ms. Rivera. There are 5 cases on the master calendar. The first 2 are removal cases. The first removal case is ZB Pearl LLC and 3D Pearl LLC. The address is 53 Pearl Street in Brooklyn, New York, and the docket number is LE0728. The second removal case is 10 West 18th Owner LLC, and the address is 10 West 8th Street.
What'd you
in-
say?
And that address is 10 West 18th Street in New York, New York. The docket number is LE0656 and LE0701. There is no staff presentation on these two cases. Is there a motion to accept these cases? Ms. Otto, is there a second? Mr. Bowitz. Thank you, Ms. Rivera. Any comments on these cases? Any comments from the board members? No comments? Ms. Rivera, could you please poll the board members?
Mr. Bauer,
Yes,
Mrs. Hilton,
Yes.
Mrs. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Chairperson Hilton.
Yes.
6 in favor, 3 absent.
Thank you, Ms. Rivera. The next case on the master calendar is Cynthia Chapin, and the address is 482 Broadway, New York, New York. And the docket numbers are TH0209, TM0097, and TN0277. Ms. Lee, please present this case.
Thank you, Chairperson Hilton. This case involves a harassment application, a diminution of services application, and a legalization timetable violation application, all three of which were filed by the tenant of Unit 5N, also known as Unit 5B and Unit 501, at 482 Broadway in Manhattan. In her harassment and diminution of services applications, the tenant alleges that the owner engaged in unlawful harassment and diminution of services pursuant to 29 RCNY sections 2-02B and 2-04 respectively. Many allegations overlap between the tenant's harassment and diminution of services applications. The tenant asserts that the owner disrupted services, failed to repair building systems and conditions in the tenant's unit, performed unreasonable, prolonged, and unpermitted construction work, as well as failed to stop or remediate noise, fumes, and other nuisances caused by the commercial tenant in the building. The Administrative Law Judge, or ALJ, concluded that there was insufficient evidence to demonstrate harassment on the part of the owner, but that the tenant had established a claim of diminution of services with respect to gaps in her skylight, which needed to be repaired. With respect to the tenant's harassment application, this proposed order agrees that the tenant failed to satisfy her burden of proof. There is insufficient evidence in the record to support the tenant's harassment allegations. With respect to the tenant's diminution of services application, this proposed order also agrees that the tenant established a diminution of services claim only as to the gaps in her skylight. Testimony offered by a loft board inspector corroborated the tenant's allegation concerning the gaps. The loft board inspector credibly testified that there are flaps in the vertical section of the skylight which contain 1-inch gaps on multiple panels. According to the loft board inspector, the gaps could potentially create a draft within the tenant's unit and cause heat loss. Therefore, the gaps need to be sealed. Although the record shows that the property manager has been responsive to the tenant's complaints regarding the skylight, at the time of trial, necessary repairs had not been made because the property manager was in the process of hiring a new contractor. Because the property manager's efforts to inspect and repair the gaps are incomplete, the gaps remain an ongoing issue and constitute a diminution of services. In her legalization timetable violation application, the tenant alleges that the owner failed to comply with the code compliance deadlines as set forth in MDL Section 284.1 and 29 RCNY Section 2-01A, because the owner did not achieve compliance with Article 7B and because the owner did not obtain a final certificate of occupancy for the building. The ALJ concluded that the tenant failed to establish a violation of the legalization timetable because as of the last trial date, the building had a valid TCO, which was equivalent to Article 7B compliance, and because legalization work in the building appeared to be over 99% complete. This proposed order agrees in part and disagrees in part. This proposed order agrees that the owner is not in violation of the legalization timetable as it relates to achieving Article 7B compliance. However, this proposed order finds that the owner is in violation of the legalization timetable under MDL Section 284.1V and 29 RCNY Section 2-01A8IV, specifically for failing to obtain a residential certificate of occupancy by July 2nd, 2012. The owner contends that after obtaining a TCO for the residential I&D units in the building on April 1st, 2011, it had taken all reasonable and necessary action to obtain a residential certificate of occupancy pursuant to the MDL. However, the owner does not provide an adequate defense or explanation as to why, despite taking all reasonable and necessary action, it failed to meet the statutory deadline for obtaining a residential certificate of occupancy under MDL Section 284(1)B. The owner claims that it has been unable to complete outstanding legalization work in the tenant's unit because the tenant has repeatedly refused to grant access to her unit. But this argument, which the tenant disputes, does not necessarily relieve the owner of its obligation to legalize the premises and to comply with the code compliance deadlines. In the event that a tenant refuses to grant access, an owner may file an access application with the Loft Board, which the owner has not done here, so that legalization of the premises can proceed. In sum, this proposed order denies the tenant's harassment application, as well as grants the tenant's diminution of services application solely to the extent that the gaps in the flaps of her skylight constitute a diminution of services. The owner is directed to restore the tenant's skylight so that the gaps are filled. Furthermore, this proposed order grants the tenant's legalization timetable violation application. The owner is directed to maintain a valid TCO for the residential portions of the building and to diligently take all reasonable and necessary action to obtain a final certificate of occupancy for the building.
Thank you, Ms. Lee. Just for the record, how many pages is this order?
I think there were 11.
Good job. Thank you. Is there a motion to accept this case? Mr. Barwitz, is there a second? Ms. Otto, I'll entertain comments on this order now.
I will make a similar comment that I made to earlier. In these 11 pages, it's fair to say there were a number of questions and issues that were brought up and discussed in detail, and particularly it was a bit of a really delving into some of the minutia of the code compliance deadlines. So thank you, Ms. Lee, for such a thorough outline of an incredibly complicated case.
Thank you, Ms. Rosalind. Mr. Delaney?
Yes, first off, I want to disclose to my colleagues on the board that I did have one or two telephone conversations with the applicant back probably around the time that this application was filed. I made clear to the applicant at the time that I was happy to hear about the conditions in the building, but I did not want to talk about anything regarding any pending or potential Loft Board case. Our focus was more on looking for support from elected officials to try to move this along. Clearly, there's some problems with this building. I would also note, in addition to an 11-page proposed order, the backup materials for this case are in excess of 3,600 pages of materials. Clearly, there's a lot that the tenant has documented here. And I wonder, Ms. Lee, if you could just summarize the board's position in agreeing, the staff's recommendation in agreeing with the finding of no harassment made by the ALJ.
Sorry, Mr. Delaney, could you repeat that last part?
Made by the ALJ.
I'm sorry, so you'd like me to summarize the findings of the ALJ?
The conclusion that that the issues in this building do not rise to the level of harassment.
I apologize, Mr. Delaney. I have a little bit of trouble hearing the last part.
I'm sorry, I'll try one more time. If you could just summarize the conclusions that were made by the administrative law judge and agreed by Loft Board staff that the issues in this building did not rise to the level of harassment?
Yes. So basically, the administrative law judge found that there was insufficient evidence to show that the owner had harassed the tenant. The tenant did not meet her burden of proof. The tenant did not show, with respect to the commercial tenant in the building and her harassment claims with respect to the commercial tenant, the tenant failed to show that the owner or the commercial tenant had acted on behalf of the owner to force her to waive her rights or to make her leave her unit. With respect to the other conditions on the premises, the administrative law judge had opined that there was insufficient evidence and that there were various reasons as to why her harassment allegations did not prevail, some of which include the fact that the statute of limitations for her harassment claims had barred some of her claims. There was equivocal testimony and lack of corroboration. The nature of the alleged damage or disturbance did not rise to the level of harassment. The duration of the alleged act of harassment, as well as the owner's good faith efforts in accommodating the tenant, in responding to the tenant's complaints, and in performing repairs, had all factored into the administrative law judge's recommendation. And for those reasons, we, or the law board, or this proposed order, found that, agreed and found that the ALJ was correct in her analysis. And as far as, oh, you're welcome.
Go ahead.
Did you also want me to go into the diminution of services claims?
Sure.
So also with respect to the diminution of services claims, aside from the gaps in the flaps of the skylight, the ALJ had found that, again, there was insufficient evidence to support the tenant's other diminution of services claims. Some of the reasons were that the nature and the duration of the alleged diminution of services did not rise to the level of a diminution of services. There was also, again, equivocal testimony and lack of corroboration. And some of the claims or some of the conditions that the tenant had alleged were also resolved by the time, I believe, the ALJ had issued her report and recommendation. So again, those were some of the factors that were considered by the ALJ, and those are the same reasons that this proposed order agrees with the ALJ.
Thank you.
Thank you, Ms. Lee. Are there any other comments on this case? Absent any comments? Additional comments? Ms. Rivera, could you please poll the board member?
Mr. Bauer,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
No.
Ms. Roseman,
Yes.
Ms. Otto,
Yes.
Chairperson Hilton,
Yes.
5 in favor, 1 against, 3 absent.
The motion carries. Thank you, Ms. Rivera. The next case is Courtney Nierberg, and that address is 132927, 13 through, correction. The next case is Courtney Nierberg. The address is 19 through 27 J Street, Brooklyn, New York, and the docket number is PO 0111 and TA 0263. Ms. Lynn will present this case.
Thank you, Chairperson. Case number 8 in the matter of Courtney Nierberg involves a protected occupancy application and a rent overcharge application filed by the alleged occupant of 19-27 J Street, Brooklyn, New York, Unit 201, aka Unit 2B. The matter was transferred to oath for adjudication. On January 21st, 2021, applicant's attorney sought to be relieved as counsel based upon applicant's failure to communicate with his firm. The administrative law judge granted his application. Subsequently, the applicant contacted oath and a conference date was set for March 19, 2021. Applicant failed to appear for conference and the second conference date was set for May 27th. Applicant did not appear for the May 27th conference. On June 11, 2021, a final notice of trial was issued to the applicant, setting a trial date of August 4, 2021. On August 4th, the applicant failed to appear for trial. Owner's counsel moved for dismissal of the application, and the ALJ recommended denial based upon applicant's failure to prosecute. The record indicates that applicant has failed to appear for trial and did not contact oath nor submit a written request for reinstatement of the application within 30 days of the trial date. Accordingly, applicant's protected occupancy application and rent overcharge application are dismissed for failure to prosecute.
Thank you, Ms. Lynn. Is there a motion to accept this case? Ms. Otto, is there a second? Mr. Hilton, thank you. Are there any comments on this case? Absent any comments, Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Chairperson Hilton.
Yes.
6 in favor, 3 absent.
Thank you, Ms. Rivera. The final case on our master calendar is American Package Company, Inc., and that address is 226 Franklin Street in Brooklyn, New York, and the docket number is LS 0264, and Ms. Lynn will again present this case.
Thank you, Chairperson. Case number 9 in the matter of American Package Co. is an access application filed by the owner of 226 Franklin Street, Brooklyn, New York, against Theodore Lockhart, the tenant of Unit G12. On June 7, 2017, tenant and owner executed a stipulation of settlement in which the parties acknowledged tenant's protected occupancy status. The stipulation also named Philip Hubbard as tenant's roommate. On October 21st and November 5th of 2020, owner served access notices on the tenant, but not his roommate, Philip Hubbard. Owner then filed his access application with the Loft Board. The Loft Board staff transferred the matter to oath for adjudication. At oath, the presiding administrative law judge permitted owner to adjourn the trial so that owner may serve access notices upon Mr. Hubbard. On March 15 and April 5th of 2021, owner served access notices upon both tenant and Mr. Hubbard. A trial was then held. After trial, the ALJ issued a report recommending granting owner's access application. This proposed order rejects the ALJ's recommendation and finds that the owner's access application is denied. Given the substantial rights implicated by an access application, Loft Board's notice requirements must be strictly followed. Loft Board rules require that all occupants be served with the access notices prior to the commencement of an access application. Here, before filing the access application, owner only served the tenant and not his roommate, whose occupancy was known to the owner. While the ALJ had permitted owner to adjourn the trial to reserve access notices upon Mr. Hubbard, nothing in Loft Board's rules or prior orders permits an owner to retroactively correct defective access notices or issue no new access notices within the context of an existing access application. Further, Loft Board precedent also justifies the imposition of a $1,000 fine against owner for its failure to adhere to Loft Board's requirements for access notices. This is the second access application the tenant has had to defend against. In February 2020, owner has filed a previous access application, which also failed to conform to Loft Board's access notice requirements. Accordingly, the proposed order finds that owner's access application should be denied and that a $1,000 civil penalty be imposed upon owner for his failure to comply with Loft Board service requirements for access notices.
Thank you, Ms. Lynn. Is there a motion to accept this case? Mr. Delaney, is there a second? Ms. Roseland. Thank you. Any comments on this case?
Yeah, I would just reiterate, I'm not comfortable in terms of how this case turns out and reversing the ALJ judge's decision. And I not comfortable in terms of even the interpretation in terms of occupants and notice. So I think that just it's a troubling and expansive definition that could lead to unintended consequences in other areas, and something needs to be cleared up.
Thank you, Mr. Hilton. Are there any other comments? Ms. Lynn, I just have one question. The fine against owner, was that because because it was a second thing, or would it have just been the fine against the owner in this case? $1,000? Was it because
$2,000.
$1,000? Was it because of the one-time incident, or because it was because it had happened before? Would it have?
Both. We have precedent on both directions. The case that we're relying on, which we say that the owner does not have the opportunity to cure defective access notice, that also resulted in a $1,000 imposition, civil penalty against the owner. We also have another case in which explicitly also finding on $1,000 because it was a second access notice the tenant had to defend against. So on both grounds.
Okay, great. Thank you. Any other comments? No comments? Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Hilton,
No.
Mr. Delaney,
Yes.
Ms. Roseland,
Ms.
Yes.
Rose? Okay.
Ms. Otto,
Yes.
Chairperson Hilton.
Yes,
5 in favor, 1 against, 3 absent.
thank you. The motion carries. Thank you. Board members, I really appreciate the detail, the level of scrutiny and so on, these orders, and I appreciate the level of preparation you made for these. I want to thank the staff especially for the hard work that they put into preparing these orders. It is been privy to having to review all these things. It is tremendous, and it goes to the level of prep Mr. Schultz and his staff put into preparing these orders. Thank you very much. At this point, we're going to take a 2-minute break before we go into rulemaking. So board members or everyone else should just put themselves on mute and also maybe off camera. We'll be back in 2 minutes. Please keep the record alive. No, right? Thank you.
Yes, yes.
Board members, when you're back, you just take yourself, put yourself back in camera so I know. Thank you. So I need just one more board member to indicate they're ready, and so we can proceed. So I just want to make it clear, we don't have a quorum yet to proceed. Just as soon as another board member comes on, we'll proceed. Maybe Mr. Bowers, maybe you're the expert here on that. Can I, is it at the beginning of the meeting or anytime?
Well, we can proceed, but whatever we do is really off the record.
Oh, you don't want that, no?
We're working on the assumption that neither Mr. Hilton nor Ms. Rosalind is back yet. Is that what's holding
Right,
us up?
we're waiting on either one of them just to, if either or comes on, we can.
would it be okay for me to simply put out and start to discuss if there's any thoughts on how we might go about this? So without getting into the content of the rules, I've heard from a few board members about, the best way to do it. And this is my third time doing this. I know it all predates me. So if we can, and it don't be off the record, and I could recap it for whoever joins, but if anyone has thoughts or opinions on the best process to do this, that will be not too tedious, appropriately dynamic for what we're doing, which is making rules, which I find very exciting. In other words, if you have thoughts or critiques on the way it went last time, I'm glad to hear it. If you have a vision on how you'd like it to go this time, I'd be happy to hear it. Otherwise, I'll do whatever I think I got to do going through it.
On the other hand, if we proceed and then publish it, make it available for anybody, for the city and state, anybody else, then I think we can proceed after it's published and distributed.
Okay. So anything we do out of this process, especially, will be finally published, and there's nothing here that I think would require a vote.
You mean there'll be no action, but do we have a meeting with less than the quorum? Do we have a meeting? Do we have an official board meeting?
I mean, I wasn't trying to push it. I certainly think anything of substance, it'd be best to have a quorum in the absence of doubt. I was just going to speak a little bit about, elicit any opinions about whether I should go one by one, whether anyone had items they want to start with, whether we want to just say, looks great, Kevin, we're done. I'm not sure I endorse that one, but I'm open to ideas on how to do this in a way that works for everybody.
I know Stefan, you can't answer this question. But how much more time do you?
Everything is,
never mind.
all our conversations are moot. So thank you, Ms. Roslin. We're back now on the record. The next item on the agenda is rulemaking updates, and Mr. Schultz will lead the discussion with the assistance of Ms. Lynn and Mr. Clark. Mr. Schultz.
Thank you, Chairperson. So we're back with some more rulemaking. The document I sent you this time, it has the comments right there on the page. I hope that's easier. Last time it was on like a different document and you had to decode it. So I'm hoping this is easier. You might notice there's more words in the comments. That's because some of it's more complicated. I also leave little to the imagination sometimes. It doesn't mean, we have to cover every piece of those notes. I think what I'd like to do is ask if there is a section or a page that is particularly of note or urgent for one or more of our members. I'd be happy to start there. Otherwise, I could just go page by page and be as efficient and thorough as I can. And if I'm too much of either, please speak up. Is there anywhere anyone would like to start, particularly? Okay. Yes, sir. Yeah, Mr. Delaney.
I had raised the question with Kevin yesterday in terms of how are we going to proceed with this discussion today? Because for the last few months, to my recollection, we've kind of worked off either a set of talking points generated by Mr. Clark or Mr. Argove on certain topics, and then we've kind of been going through the law department's comments. And I think maybe, particularly since we're going to have another meeting, an extra meeting in November to try to move things along, maybe part of what we should spend some time on this afternoon is trying to figure out how to close this process down. And I don't know, do we have everything now from the law department, or are there still things that we don't have? Any sense of the timing from that vantage point?
Yeah, so just to give a better definition, what you have in front of you are not word for word what the law department's comments were. They are notes, my notes essentially, having reviewed them whenever I can, giving context to it. Their comments weren't really put on this piece of paper that you passed. So I was taking their comments, doing some interaction with law department to make sure I understood them, and then trying to put them in a way that landed on a recommendation where I could, and particularly when I filtered back and forth with whatever law department felt, something that I felt was worth bringing to this board. There are items yet that have not been shared with you because I guess to put it most bluntly, I am still working out my own understanding of them and what law department wants or thinks. And so this represents what I think is ready for discussion for me to make it easy for you, if that's helpful. So there is more. I would say, there is not a lot more. And I would love to have been able to get everything processed and put in front of you so you had a better sense of the universe. That would be what I'd try to do for November 4th, is say, look, it's all here. Now we just got to get through it. So suffice to say, this is more than most of it, more than half of it in front of you between last meeting and this meeting. Some of the ones that you haven't seen yet are frankly I think one of the more complicated ones that I need to get my head around. So I did not put them in front of you because I wanted to be able to give context that's helpful. Any other thoughts or comments on what Mr. Delaney brought up? I'm going to start on page 7. Again, I'm going to be both efficient and thorough. If I head in either direction too much, I am genuinely open to feedback. I do want to know. I agree. We want to close this off. So I don't want to belabor anything unnecessarily. On page 7, essentially the definition of family, as law department saw it, and based on what I learned by trying to learn the history of this, is that this was a created definition that was crafted as a hybrid to serve two purposes. And law department has suggested that it doesn't serve any purpose very well, because what the rules end up doing is defining the same word multiple times throughout our rules without I guess sufficient clarity. I'll leave it at that. In most cases of our rules, the word family has a meaning that really would be the same as the MDL. And law department asked, well, if that's true, why not just say that? And part of the answer was because one part of our rules, the MDL, is not apt. It requires a different definition of family. So as I understand, the solution was to try to create a multi-purpose definition, but law department is suggesting that we just say it like it is, and say family will be defined as the same as set forth in the MDL 4.5 unless otherwise indicated. And then in the place where we need to otherwise indicate it, we do, and it's defined the way it needs to be there. I tried to make that as simple as possible. And so instead of talking about it, I'll open it up to questions or comments. If you want a simpler version, I endorse, having reviewed it. I see the suggestion law department made here. I think it's proper and appropriate, and it doesn't hurt anything.
So where's that proposed language, Kevin?
So it's in the
The comments?
sidebar. Law department's the 5th paragraph down, 4th paragraph down, 1, 2, 3, 5th one. Law department suggests hybrid definition is ill-advised, and instead stating merely that family means the same as set forth in MDL 4.5 unless otherwise stated, unless otherwise indicated. And for this part, that would be the definition of family.
So just where the word family begins, just that piece?
It would be striking everything you see there.
Yeah.
except the words family means, yeah, it would be striking most of this definition in
Sure.
favor of one that Matt just explicitly says family means what the MDL means unless otherwise indicated. And there is a place where it is otherwise indicated for the unique purposes of that section.
So doesn't that make sense if the purpose is for a building to go from an IMD to an MD, that it should, for the most part, we don't want something that counts as one thing during the process, but then is not the same thing once the building leaves our jurisdiction, correct? That's the thinking?
I guess I'll be precise. The definition throughout most of our rules to match the MDL works well, except when a section that discusses succession and then family in order to match other areas of law, it's more apt to have a different meaning. We're not editing that section of succession in this rule process, but I pasted it at the end for reference if anyone wants to get into it.
So Kevin, just to make it clear, I'm sorry, Ms. Roslin, did I step on you a little bit? No, you're good? Okay. To make it clear, this part in the definitions where we have small I or Roman numeral I, a person or persons, regardless of whether such persons are related by marriage or blah, 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 and carrying on, the entire piece would be stricken with just that language that you says family means the same as set forth in the MDL 445 unless otherwise indicated. That would just be replaced by that?
That would be the change, yes.
Okay. Is there anywhere in this rule that MDL 45 definition of family is indicated anywhere? To make, I'm talking about simplicity. We'd have to go back to MDL 4.
No, yeah, so it's not repeated, but in the sidebar I have that language directly below. MDL 45 states a family is, and then it has a language that looks a lot like what's there.
Right.
Not exactly.
Okay. So was there any? Do you know if there's any difference between that plus what we had there?
Yeah, I mean,
significant difference. Anything that's of consequence.
The differences that I came to understand by reading it and also speaking with some staff who, frankly, as best as they could, are trying to bridge the gap between, prior years and myself, is that the language differences were an attempt to service both dual needs and to try to make family work for the success.
For both these two, yes. Okay, I got you.
And the law department's reaction is you probably don't need to do that if you're already defining it. This is more general. Let me give you a general proposition at law department, because this will come up again. If you're going to make a definition, make it so that it works everywhere, except where you say it doesn't work, and then you got to define it again for that special section. I don't think I made it simple. But if we wanted to match MDL, then we should say it. This creation goes away from the MDL in ways that we might not be able to anticipate why. And the records we saw was that for the most part, it should be matching the MDL.
Okay. So in the other places where it doesn't match the MDL, it will be spelled out.
And it is, yes.
Okay, thank you.
And it's not part of this this edit. But again, that language is at the end of your PDF if anyone cares to see it.
Okay, thanks. I'm good.
So if I understand correctly, what we currently have in our draft is basically a mashup of MDL 4.5 with some of the language that's on 205B8, whatever. And if I recall correctly, we inserted that into our rules some time ago to try to dovetail with the Braschi decision in a rent stabilized building regarding succession between people who lived together but weren't married. And at the moment in 205B, the language is family should have the meeting and may. So basically in 205, we currently have the MDL 4.5 definition plus the mashup. Is that right?
Yes. Yeah,
Yeah.
it's
Okay.
MDL with a little bit extra.
So the only thing I would suggest in that case is why not here in the definition section, rather than just say family means what it means in MDL 4.5, why not reiterate MDL 4.5 here and just say family as defined in MDL 4.5 means ... so that they have the definition here.
I will predict the answer law department will give, and it's that less words will be better, more precise, and less risky for the future. Because if you say both, if you say it will match and then you give the language, and then the language changes in the MDL, you run the risk of being internally inconsistent.
Well, also just further down the page, under IMD, it says as defined in the MDL 281, and same with IBZ, as defined in Chapter 60 of Title 22 of the New York City Administrative Code. So there's precedent for just referring to a different regulation. And as Kevin said, you're always then that takes precedent, because if the rules change somewhere else or the definition changes somewhere else, then there's not a discrepancy between the two.
Point well taken.
I'll say for these and others, just again, kind of a matter of process. I very much wanted the board to see the version that they passed in the same version they saw it, juxtaposed with the comments. So I did not go about inserting edits into anything. I felt that might be unnecessarily confusing. There will be I believe, a time, and I don't want to belabor this, where, those changes any changes will be incorporated, and voted on again. And I don't want to suggest we want to talk about things forever, but, this conversation needn't be the end all be all on any given item.
Okay. Dangerous waters, Mr. Mr. Hilton, did you have a question? I thought you raised your hand. Christian. No, you didn't. Okay. All right. Thank you, Mr. Schultz.
I'm going to take away that I can incorporate that change into a future version. If this conversation led someone to take pause with that and they want to share that with me between now and any time, we can. That's I can take that. I can take that offline and then we can discuss it publicly. I'm going to move on to page 9. Page 9, and I'll just get to it. The law department's suggested language is in the sidebar comments is in the 5th section. And the language that is added, it says a special permit means, and the language that is added is an approval granted pursuant to a. And this is a language thing. Essentially, the language as it says special permit means a grandfathering procedure. And the law department would say a permit is not a procedure. At least seemingly that's not what one means. The permit is the thing that comes out of the procedure. And I think I did not see any harm in considering and adopting that change.
I agree.
There's another change in that.
Sorry, I have a question about that. Is in our rules, so this is saying in our rules, a special permit is an approval pursuant to a grandfathering procedure. So it's only a grandfathering procedure? You can't get a special permit for something else?
I'll be honest, that question is going to go afield of my experience so far. Haven't dealt with this particularly yet beyond looking at this rule change. Special permit, and I will say, just reading the prior language that existed previous to this, or as I should say, as it was written when I inherited it, it seemed to be that's what was intended. Special permits are for grandfathering procedures.
Specified in the zoning resolution, which involves a discretionary determination and approval by the city planning commission. A grandfathering procedure. A
Seems like Heather,
discretionary.
you'll have to go into the zone, into the
Well, so I get this, a special permit per the zoning resolution is anything that doesn't comply. So you can get a special permit to have a larger dormer than would necessarily be allowed, or, you know, there's different, right?
Well,
Or no?
these are the special permits for our rule. I mean, special permits are a phrase that can be used in a lot of places, but when it's referenced in our rules, it'll mean this.
Okay, that's my question. That's the answer. Thank you.
so Department of Buildings have its own special permits.
They're all special.
And everybody's special.
There's another suggested change by law department late in that sentence that changes the words and any to or. And it's essentially, the language reads approval by the city planning commission or other entity. I'd have to go back to the notes as to why law department pointed this out, but I think they felt the language as existed was unnecessarily limiting, as if it was indicating something particular, as opposed to keeping it open to whatever organization ends up doing this in the future.
That's right. That's right. Sometimes that language is there so that if the city planning commission is no longer the entity, then it is the like successor entity.
So I think the language, my instinct was that change achieves the intended goal even better than the existing language.
Mm-hmm.
Any questions or comments on that? All right. Moving on to page 12. Law department flagged this section B under 1-17. And I got a note or some insight that this language was the language that you see in the one what was passed on the left side of the page was provided to the board by the mayor's office chief privacy officer. So this is something that the mayor's office wanted included for reasons that make sense if you read it, looking out for confidentiality. Law department felt that language unnecessarily mixed the mayor's office confidentiality concerns with FOIL. And they are distinct. FOIL has its own confidentiality provisions and measures. So whether it's equating or conflating or whatever it did, the recommendation was essentially to break it out in a way that, again, to put it simply, I think says the same thing, but prevents that conflation of FOIL and what mayor's office is trying to do.
So do you know who had given this language? Was it us crafting it on mayor's office? What was that off? On the mayor's office concerns, or what? Or did they?
Privacy concerns.
Or did they give us that language to put in? Do you know how that came about?
I'll invite Mr. Clark if he remembers or knows, but as I understand, it was given to us wholesale by the mayor's office. If it changed in the interim, I'm not sure.
Okay. Stefan, do you know?
Yes, I believe it was wholesale.
Okay. All right, but Kevin, I mean, but you believe this law department's thing to be valid, right? I mean, it's.
Yeah. I mean, I like it. I like it better. I think his comment is notable. I mean, who knows? We're lawyers. We're supposed to try to think of every eventuality. I think the mayor's office's purposes are achieved, and I think that any potential confusion with what FOIL law would allow or not allow is now properly separated.
This, just out of my curiosity, I mean, 1-17 talks about public access to records.
Right.
Isn't that FOIL?
It is, which begs a question I was able to avoid, or an issue was why is this even in that section? Why is this even here, right? In other words, I tried to keep what I brought to this group as simple as possible by suggesting to the law department that this is as good a place as any for it, because they had suggested, what is this doing here?
Okay.
So,
all right, thank you. So the language we're looking at is what section?
It'd be the B1, 2, 3. Essentially, parts of the paragraph are broken up into individual sentences, with the third one kind of being the newest addition, speaking to FOIL on its own merit.
I think it's important for the record just to read what the law department suggests.
Sure. What the law department suggests is that that section B be drafted to say confidentiality of lease information. 1, the loft board will keep confidential all personal information in leases submitted with registration applications. 2, the loft board may release personal information about a unit to the current owner of a building and/or to the current occupant of a unit or other responsible party to the extent the loft board believes such release is necessary to decide an application filed with the loft board or a case filed in court. And again, so that language is not newly created by law department. That's just what City Hall had given. 3, personal information will not be disclosed pursuant to a Freedom of Information law request except in accordance with or as required by such law. So again, trying to make it clear, this isn't possibly trying to overrule FOIL law or go against it or conflict with it. We would have to write a law that's consistent with FOIL, or a rule, and that's what this is achieving.
I have one question about the word will there. I mean, do you think it makes a difference if that it should be shall?
I'll find out and give you a recommendation. I can't.
It seems like they've always wanted to have these affirmative.
I understand.
Words, and shall is more. I mean, I'm not sure which one, but I think they're consistently we've been using shall, right?
I'll have to do a word count. Honestly, I think must, shall, will.
Well, pick a choice.
I haven't cracked the code on that yet.
We should decide which one we want to use. Go ahead.
Anything else on that section's questions or comments? Okay. Either way, I'll share. The comments are front loaded. So the pace, this one-page pace, is not what we see for 178 pages, I promise. Now I'm going to get into some minutia, but I'm going to leave nothing to chance. On page 14, there's some bracketed words. Let's see, bracketed words. They should be deleted. Bracketing is not necessary when we are creating new language. It's all underlined. So we could just delete it. It doesn't have to be there because it's not being deleted from anything because it's within language that's being added wholesale. That's a form, that's a rule crafting form issue. I won't belabor them unless you want me to, but I will point them out. And as we get to understand them, they'll go very quickly. Any questions about that on page 14? The meaning does not change. If for the avoidance of doubt, the meaning does not change by taking out those brackets. Moving on to page 15. At the bottom, one is something we talked about already, so I'll skip it. In 6, this is a consistency of language matter. So what's in the version that was passed reads, a date, which would be the date that these rules are passed. And then it reads, which is 9 months from the effective date of the rules necessary to implement the provisions of, and on and on. Those words mean the same thing as what we've said in other parts of the rule, more times, 5 other times. And so to make it consistent, it could and should read instead by insert date, which is 9 months after the effective date of this amended rule. So that language, after the effective date of this amended rule, are the words that have been used multiple times to express that date. And this language reaches the same conclusion with different words, so it is recommended that we be consistent. Any questions?
Why is it necessary to put the date in there, or and the 9 months? I mean, is it just to make it clear?
Yeah, I mean, I see it a lot in our rules, whether it's stuff we're changing here or not. There's a lot of date, which is, this many, the 1 year after the effective date of this rule. It seems to be, both precision as well as some education for the reader. Perhaps it's not just doesn't come off as a random date. The date of the effective rule is a start of a timeline in many cases. And so it's being referenced and then somewhat defined for perspective. I see it in our rules a lot and in a lot of laws. Any questions on page 15? Okay. Page 16. There is some language under affected parties. This is one where I'll confess I'm more in the weeds than normal. So we could skip it or we could talk. I'll need some historical insight that I have yet to really find. So I'm speaking hopefully to board members who were here at the time. There's a question as to what is the purpose of this Roman numeral 4 under affected parties. This is the section that talks about affected parties for applications, meaning who has to get included in the various notices and such. And I'm going to start from the top of that. It includes the owner. It includes any responsible party, which is also like parties associated with the owner usually. It describes prime lessees and sublessees in the building, including residential and commercial and manufacturing tenants, which is pretty broad. And then there's a fourth that says all units of the building, if different from the prime lessees and sublessees. So I can gather the effort is to be broad. I get that.
All occupants.
Well, so yes. So that's the question. Why the word units? The law department says units is not a person, so we need to put a person in there. And it's tempting to jump in and put occupants or tenants in there. And this is where I'll kind of fall off a cliff. I think from what I can gather, there was conversations about whether or not to put tenant and occupant there, and perhaps it was avoided for some reason. I'm not. That is kind of conjecture at this point. I don't want to replace it without understanding why units was pursued, if that was an active effort. I don't think we can keep it, but I don't have the context personally at this point to fully understand why occupant or tenant won't work there. And so it comes down to, what did the board mean or want when it added this? What was it trying to include when it added Roman numeral 4?
So wouldn't an occupant or like some other person would be maybe somebody who's there but doesn't have skin in the game kind of thing? Like so number 3 is you're a tenant, which means you have a lease or an agreement. And then number 4, I'm just reading as it reads to me, would be anyone else. So it could be, you know, your sister who comes and stays once a month with you or something, right? Which is actually something that came up earlier in the discussion on one of the cases about who, you know, with the who everybody is.
Yeah, and so the words occupant and tenant are both defined, and to put it simply, occupant is a pretty broad term, meaning you know, a lot of people. I'll leave it at that, protected or not. And then tenant is unsurprisingly not as broad, and so you know, there is, I think in here we put a, you know, a potential suggestion of language to achieve what we thought the board wanted to do by using the word anyone. Anyone residing within or commercially utilizing any unit of the building, if different from the prime lessees and sublessees. That's actually the board's putting together of language, the board staff, I should say, not law department, recognizing what law department was saying, but trying to solve it in a way that was our best guess is what the board was working with. So other options do include putting the word occupant or tenant in there. But as you said, that has, you know, that goes back to our prior conversation of the breadth or narrowness of those words. As it stands, you know, the Loft Board staff thinks that this language at the end, anyone residing within or commercially utilizing any unit of the building, if different from the prime lessees and sublessees, we crafted it because we think it works in our experience of things. But I wouldn't say I'm not open to hearing what the board thinks about this or the history of things. All right, I guess we nailed it.
I don't have anything to add in terms of the history. If there was some reason we came up with this whenever this was put in, and this may go back to the beginning of the board's rules, I can't come up with a historical nugget on this one.
Kevin?
Yeah.
I was thinking all occupants and occupants of all units of the building if different.
Yeah, I mean, so occupant, use of the word occupants would have, you know, would lend that breadth, broadness to what's meant and intended here.
So I know, I'm just saying, the law department's suggested language, anyone residing.
I'm going to interrupt you, sir. It's not the law department suggested language.
Oh, this is your.
Flagged this as internally is improper to refer to a unit as a person, essentially. And so in trying to solve it without using the word occupant or tenant, which was what we, at least the record, the memories and notes we saw had might be the problem, we crafted that as a consideration.
Well, so doesn't,
I'm not endorsing it like with vigor here, obviously. I'm trying to get to the bottom of it.
but then, and I think we're thinking about this from a loft law side of things, but if it's anybody who's occupying a building and you had a business that had 50 employees, those 50 employees occupy that building. I mean, right, it gets really broad, thought one. And then thought two, is there a reason that number 4 needs to be in there at all?
That is That is a good, yes, and that's maybe a tighter version of what did the board intend by putting it here? Does it need to be there? Do the first three get the job done for the purposes of the board? Or yeah, what was trying to be captured with that last group? My sense is that it was intending to make it as broad as possible, which I didn't want to throw away by suggesting, throwing away 4. It would eliminate occupants if essentially, it's funny where you're avoiding the word occupants, but if you took away 4, it would speak to tenants. Tenants would be affected parties and for coverage, harassment, and hardship applications, just to make it clear that that's the universe. If you look below, there are other types of applications that define affected parties in different ways. And I'll confess I haven't fully examined those, but it looks to me like these affected party groups were tailored for the types of applications.
That was actually going to be my next comment. Does it, certainly the affected parties shows up more than in just under harassment.
Rather than, let me start by saying I'm happy to hear anything else, but perhaps rather than belabor this any further, I will try to go through some minutes perhaps and see if I can find anything enlightening in the past on this one. And if I can't, then I'll come back with my best suggestion November 4th. If I can, then I'll share that enlightening history. Would that be okay? Okay. All right. 17, page 17 is full of comments. Again, the pace does not keep up like this page by page, truly. Page 17, the first comment law department made is under section C here in the middle of the page, service of the application. And law department points out this language that says the applicant may serve personally or by. And so law department's concerns or questions and comments were that there's no discuss, whereas for all the other types below, there's all this discussion on what proof of service would be. But for personal service, it doesn't say anything about what would evidence personal service, which I thought was a helpful point. Secondly, law department felt people wouldn't know what serve personally meant. And I've been in the lawyer bubble so long, maybe to be fair, law department are lawyers. And to their point, personal service is probably the legal term of art that would resonate, or is at least like Googleable. So I think using personal service makes enough sense instead as a threshold. And then also so the language that was, I think this was crafted by Loft Board staff, not by law department, but it's in response to law department's comments, is to say the applicant may effectuate personal service providing proof of service by sworn affidavit, and then continuing. So sworn affidavit being, to me, the most common realistic version of evidence for personal service.
Personal service is defined, right? In, what is it, the CPLR? Is it, what is it? Is that what I'm saying?
Yeah, it's defined, the New York court, I don't know if it's actually in the CPLR or not. I should look. I mean, I did what I thought a human being would do, and I Googled it, and I found something that made sense that was on a court website, on the New York State Court's website. And it actually didn't have a citation. It was more of like a user-friendly FAQ type thing. So I'm not swearing like legal citation to it so much as, a common usage of the word that anyone would endorse and understand. And again,
Are you suggesting, or would we pull it out of the first paragraph then and make it part of the list of options? Would it be a number 5?
No, and I wouldn't say that's a bad idea. was trying to do as little changes as possible to get the job done. It's obviously a
I
nominal.
understand that, but it also, by having it as part of the first paragraph, it makes it, it prioritizes it a little bit. So it's kind of saying like you can do it this way, which is the way it's usually done. And then there are these other options as opposed to an option of equal weight.
Yeah, I think putting it on the list would be either fine or better, truly. Does anyone have any concern about that? Yeah, I think it would fit just fine as part of the list. I'm going to move down the page a little bit. Anything else on that? I'm going to move down to right below, actually, number 1, talks about service by email. And this I remember hearing before I worked here. I started listening to some meetings as a member of the public, and I heard all this get talked about. So I actually kind of remember what was talked about a little bit. Service by email was something that the board at the time wanted to try to allow as much as possible. And it came down to saying, well, we can allow it, but there's got to be consent from the affected party. It's not just, you don't just get to email someone and effectuate service unless they've agreed to that, because it's such a different modern version of service. Suffice to say, the law department's feedback on that change is in this comment A10 in the middle of the page, and it removes language that says a current and valid email address. I think the thinking is that the purpose here is that you're going to send it to whatever email address they gave you, and to create a standard of current and valid is not something that really anyone can assess. And I could see this being misused under the law. So the proposition being, if a party has consented to use an email address, then it's the email address they gave you that counts, whether current or valid or not, if that makes sense. So it replaces that language in a different part with email address for such purpose. I don't know if talking fast helps people or doesn't help people. I'm going to read it as proposed from top to bottom, and this recommendation would be to replace 1 that's on the left with the number 1 that's on the right. Email, if the affected party consents to such service and has provided the applicant with an email address for such purpose, proof of service by email consists of a copy of a delivery receipt from the email server indicating the email was delivered to such email address. Any thoughts or comments on that? It's narrowing down, saying that the one you gave is the one that's going to get used and it's the one that's going to count. Moving on to number 2, which discusses. Yes.
Kevin, I have one thing. Should we say if an effective party instead of the? Because it seems like we're talking about each. No, I don't know. Does that make a difference?
If it matters, I'll let you know. I think the effective party is kind of used throughout. I'd have to look.
It is, but
the affected party is kind of used throughout.
It's just that there are many affected parties. The word "the affected party" seems to indicate that there's only one or something. But
yeah, well, there's each affected party. I think the is appropriately precise because it's not just any, it's the one that's referenced in the upper section that we're talking about. So and, if I'm being really nitpicky, I think and creates this tiny sliver of ambiguity that we don't need, because we're talking about a specific situation, not a just any theoretical situation. I'm open to hear more on that.
it's fine.
All right. Section 2 talks about faxing. And the comments essentially are to try to mirror what email says. One question was, why do we demand consent for email but not for fax? I don't know if I have a good answer for that. At first I thought, well, because email's like kind of new and different and maybe rare, but then like fax machines are pretty rare now too, although they're pretty much digital. So I didn't think it was necessary, but then I certainly couldn't make a compelling case against it. Adding language that would call for an affected party consenting to service by fax, as opposed to not explicitly saying so. Given, I mean, I think here's the deal. The alternative would be to not say consent is required. And that would mean essentially what's always been meant, I think. If you put a fax number on your letterhead, it counts. I'm not sure the import of not including it. I understand more clearly the import of including it, which it makes service a little more particular. Yeah, anyone?
I mean, the distinction is obviously is that email is digital. And, fax, while it's not as used frequently, has been around and is considered more or at least was previously considered more accessible. And the act of sending from fax is seen as like a signature in of itself. But I don't think it's a point to necessarily argue.
Yeah, they're similar in the sense that you're sending something out and you don't know that the person at the other end gets it, as opposed to something that's delivered, return receipt or certified mail through the USPS, right? And you get the little green tag back that so you as the sender know that it has been delivered at the other end. So to me, it makes sense that they're similar.
Yeah, I mean, it's kind of an extrapolation. I don't think anyone of us would have thought of it if the email, the consent for the email was pulled out of the idea that email is a little different and than other forms of service. And I think Mr. Hilton's right that it is different than fax, but it's also similar to fax. Service is something service is something that should be fairly precious, in my opinion. So without making it burdensome, I do think making it effective is good. And if fax machines are a touchy thing, then adding consent can make it better, more precise, I should say. I'd say it's fine there. I also think the way things are going, it's going to become a very uncommon problem. Any fax machine I know about now is like a virtual fax machine on both sides, which is basically email. Which is the other reason I landed on saying, let's just put consent in there.
If this rule goes on long enough, the post office thing will be out of date too.
Right. Okay. I'm going to move on then to, let's see, I think 4 has just the word private in the beginning. Private delivery by a private delivery service. Law department says that first word private is not necessary. I can't defend it. It'll please them if we take it out. Does anyone mind? Great.
As opposed to public delivery?
By private.
I mean, does that mean you can't use the USPS? Is that what that is intending?
So USPS is in 3.
Oh, sorry.
And then
Okay.
4 gives you the private delivery service option.
Okay.
At the bottom of page 17, let's see, some of this we already talked about. At the very bottom, we A15, comment A15 is we did last time. Comment A16. There's discussion. Oh, did I skipped one above, didn't I? Sorry, folks. I lost myself for a moment. My apology. 121E above. If we edit that, I feel like I skipped one that's
I don't think you skipped on this page.
Yeah. Oh, okay. So the change, essentially this, oh, it does relate. I'm sorry. It relates to the conversation we had last meeting. Last meeting, we had a conversation where we changed the language in on the next page. Nope, it didn't. Rather than waste everyone's time, I'm going to ask if we skip this one, and I'll remember it next time. I confess, I've looked at these so many times, I usually know what I wrote, but at this point, I'm a little lost. You mind if I skip? Unless anyone else from my staff wants to jump in and help me remember what we meant by that. All right, we'll hit it next time. My apologies. Let's go on to page 29. No, page 29 we already talked about. Page 31. On page 31 is the first in a series of several fly specking changes. One of the things that law department has pointed out is that as a matter of form, deletion should come before additions. So what you will see throughout many comments is that the change is that the brackets come first and the underlines second. Anytime that it doesn't do it that way, we're changing it for form purposes. The meaning does not change. Everything on page 31 would qualify as a rule-making form change without any effective language change whatsoever. That's page 31. And then a different fly specking thing on page 34. On page 34, Roman numeral 6 VI, there's a reference to the number 3. Study areas rezoned to permit residential use with fewer than 3 as of right units. The word 3 was added. It wasn't underlined when it was, so it should be underlined. Likewise, lower in that paragraph with the word, the number 1 in the middle. It was added. There was an effort to add, to consistency, the word 3 and then the numeral 3. And so as that was being done, things were added without being underlined. This corrections wouldn't change the meaning. It would just make sure the form is correct. Lastly, in that paragraph, the word article should not be underlined because it's within a deleted, let's see, should not be underlined as being deleted from the original text, not added. So it's brackets with an underline. That's a no. It's bracketed. It shouldn't be underlined. So those are all form things. Page 35 is more of the form, more of the deletions before additions. Page 36 is more of the same. It's the same word every time. Alteration application. Page 37 is the same. Page 38 is the same. Page 39 is the same. Page 42 is a fly specking. The proper form should be, again, it's deletions before additions. At the bottom of page 42, this is a language change. Oh, I'm sorry, nope, same thing. Deletions before additions on the bottom of page 42. Page 43, well, we talked about that one last time. Page 61, nope, talked about that one last time. Page 62. Nope, talked about it last time. Now we're moving. Page 83. This is really a form thing, but I'm going to belabor it slightly because I want everyone to be clear on these types of changes. The language that's being deleted within the brackets was marked yellow, as if to indicate that it was going to be filled in with a date, the effective date of the rule, but it is not intended. It is intended to be deleted because the September 11, 2013 is the date we want to use for the threshold for these harassment applications. We do not want that to change. And when we effectuate this new rule, that language will no longer be accurate. September 11, 2013 will not be the effective date of the amended rule. But my understanding is there's no desire to make any substantive changes to the harassment section. So that date would remain intact. It also, there's just not much logical sense in I don't think, I'm glad to hear different, making it the new date. September 13, 2011 works. September 11, 2013 works just as well now as it did then. I know I went fast. Any comments or questions? Wonderful, thank you. On to page 101. I think I might have talked about one of these before, but essentially in the version that exists currently has the word reserved with brackets around it, which is a rule drafting no-no. So law department wants to just get that fixed. If we're going to keep the word reserved, we need it without any brackets around it. I'm willing to hear more here, but last time we spoke, every time I asked, do we want to keep the word reserved? Everyone said yes. It's recommended because keeping it there keeps just the order of things clear. So unless anyone has new feelings about the word reserved in this section, it's going to keep it. It's going to take away the brackets so that it reads as laws should read. Any questions on page 101? Okay, thank you.
I have a procedural question I'd like to just raise, if I may.
Yes.
First to the chair, how long are we planning to work today?
In another 5 minutes, yeah.
Okay, yeah, that's fine. I mean, I prepared to take it to the brim, but yeah, no, absolutely. 5 minutes is fine. In fact, I mean, I could make that the stopping point. I don't think we actually worked through the hardest pieces for today, and now I am doing the fly specking. So I actually think I'm fine to stop here. I'm happy to take questions or circle back on anything.
Actually, the reason I asked is because I wanted to raise one point with regard to this meeting and future meetings where we discuss the rules. Specifically, it's hard enough going for the board members who have the rules in front of them. But unlike public meetings pre-pandemic, where if the audience came, we had copies of the rules available for them so they have some idea what the hell we're talking about. Now, I believe, for example, this draft is only distributed to the board members, and there's no way for an interested member of the public to be able to follow along. And I wonder if we can spend a minute brainstorming how we could address that.
I mean, off the cuff, the one's very safe, one very easy way to do it is, you know, the version that was passed in May is certainly not a secret, or I don't think it needs to be a secret. I don't know. I mean, it's the result of many public meetings. I would offer that the notes in the margin are attorney-client communications Not that I specifically think there's anything concerning there, but nonetheless, I think I'd want to reserve my right to not share that. But sharing the version passed in May that we're comparing off the top of my head does not seem problematic.
Does the pagination change?
I went to great lengths to keep the pagination exactly the same. That's why I transferred law department stuff onto this version. So the pagination is exactly what you did in May. And that's why I'm really holding off on making physical edits, because then the pagination gets wonky.
Right. Well, so maybe one option going forward would be to make that May version that we voted on available for download off of the board's website. That shouldn't be too tough.
I don't think so.
I'm sorry, Kevin, could you clarify that? You don't think?
I don't think that would be a problem. I'm just being a lawyer here and making sure I don't overcommit without thinking about it. But that version is certainly, I don't imagine a single thing about it that we need to be reserved about. If I find a reason to be problematic, I'll let the board know. Otherwise, we'll put it on the website.
With draft all over it?
Yes, certainly.
Across, like the top, across the entire page?
It's already there.
Okay, great.
Thank you.
Very welcome. Anything else?
Kevin, has the law department gone through the entire rule? Have they finished it all?
Yes.
It looks like they have.
Say again?
It looks like the law department has finished this entirely.
Yes, twice. So what has happened with the law department was they shared comments with us. We looked at them and provided some responsive insight, agreements, disagreements. They responded once again. And anytime that back and forth resulted in something solid enough to give you, that's what we've seen. There are some more that are there's still some engagement on some other items to figure out, so we can give you the cleanest cut suggestion. But they have been through all of it, yes, twice.
So it is possible that with the 2 November meetings, we will finish this?
Yes.
Can you be more affirmative, Mr.?
Well, I mean, I suppose law department will then again look at everything we did. To put it simply, if we agree with everything law department says, then yes. If we have things they say we don't like, or we come back with option C, they're going to look at it anew and maybe have more to say. So, and then I'm trying to do as much as I can ahead to have work to present you with things that I'm pretty sure law department's going to be okay with. That's the precursor, rather than just give it to you unfiltered and then give it back to them and then give it back to you. So I think, and it's hard to guess, I think that things we've gone over are going to be palatable to law department based on what they've said so far, which is the goal. But if you want me to be more affirmative, I'm always going to, do my job and not overpromise.
So will you tell the law department that we have perused this through page 101?
Yes. So yes, absolutely. I want to be able to engage with them with comments, essentially saying, this suggestion's been accepted, this comment's been accepted with this, small change or whatever. And then again, there are some items that require some more discourse. One specifically, one batch of things is I've actually been in touch with oath. So there are sections of our rule changes, amendments that invoke oath and the way oath does things and the way we interact with oath. So law department's comments had to be discussed with oath and law department. And so that back and forth is currently occurring. And so again, the hope is that we'll have settled with them to come to you with something that they're all good with. Any other questions? Thank you very much.
Mr. Schultz, thank you so much. I appreciate you and staff's work on the rules. Board members, before I close the meeting, do you have anything to say that can be said on the record? Thank you. This will conclude our October 21st, 2021 Loft Board meeting. There are 2 meetings scheduled for the month of November. The first public meeting in November will be held on November 4th, 2021 at 2 p.m. The primary focus of that meeting will be rulemaking. The second, and I say primary, meaning there could be potentially something else if something pressing. But the primary focus will be rulemaking. The second meeting in November will be held on November 18th, 2021 at 2 p.m. The governor's suspension of the in-person meetings requirements of the open meetings law is in effect until January 15th, 2022. So at this time, we anticipate that these meetings will also be held virtually. Information will be updated on the Loft Board's website, and also an email update will be sent through the Loft Board announcement listserv. Board members, please sign and email your attendance sheets. And I want to wish everyone a good afternoon. Thank you and see you in November.
Thank you. Have a good night.
Thank you.
Thank you.
Bye-bye.